week 3 debate, Stand Your Ground laws. Stand Your Ground laws are ineffective. This debate was created by myself, Emma Miller, Sky Jones, Melissa Coley, and Emily Van Duren. Stand Your Ground laws, a history of America's love affair with lethal self-defense. Because Stand Your Ground laws are not just ineffective but dangerous, we will begin this debate with the story of one of thousands of Americans who have lost their lives to Stand Your Ground laws. Trayvon Martin. Florida was the first to pass Stand Your Ground law. In February 2012, the murder of Trayvon Martin by George Zimmerman sparked an uprising. The 17-year-old unarmed black teen was tracked down by Zimmerman as he walked home in a gated community after going to the store. Even though Zimmerman was told to stand down, he continued to engage with the teen, leading to the fatal shooting of Trayvon Martin. Zimmerman's defense utilized the Stand Your Ground law, and as a result, he was acquitted. If Stand Your Ground laws justified this level of violence, how can we stand behind their use in America? To begin, let's review the history behind America's Stand Your Ground laws. The rise and evolution of Stand Your Ground laws. Florida passed the first Stand Your Ground law in 2005, and this is the event that is often stated as the reemergence of this form of law. It was an extension of what is known as the Castle Doctrine, a common law that states an individual may use lethal force if attacked in their home. Stand Your Ground laws took the self-defense laws to another level. Instead of retreating from a situation when able and letting law enforcement handle the situation or de-escalating the situation, under the Stand Your Ground laws, a person can stay and fight, despite the dangers that could come from staying in an unsafe situation. Under Stand Your Ground laws, a person may use up to lethal force in any area a person, quote, has a right to be, unquote. The alternative to Stand Your Ground laws is the duty to retreat burden, which requires the victim to attempt escape first, or in other words, it encourages de-escalation. It is consistently proven that Stand Your Ground laws increase conflict minimally to significantly in many states they are implemented. It should be noted here that each state has a variation to the Stand Your Ground law. While some states have stuck with the right to retreat law, there is confusion with so many states can't agree on a law of self-defense. Some states say you have to retreat if possible before standing your ground, while others waive that. Additionally, there have been incidents where more harm is caused. The harm from self-defense outweighs the perceived danger. The application of Stand Your Ground laws. Broad definitions allow for biased implementation of the law and indirectly condone violent escalations. Stand Your Ground laws require, quote, reasonable fear of life or serious injury, end quote. But who gets to decide what reasonable is, and how should it be defined in court? Furthermore, is this rule even applied in Stand Your Ground cases, as it's supposed to be? Reasonable is a very broad term, especially in this context, as what one person may consider reasonable, another person may disagree. With any other legal situation involving this term, the call on what is reasonable is left to agents of the law, such as police, who have extensive training. However, in these situations, the decision is left to a citizen with no training, and who is most likely in a state of adrenaline and fear, which is clouding their judgment. With lives on the line, do we really want individual citizens to be able to make that choice themselves, especially when that choice ends in death? Would you want your life to lay in the hands of a scared stranger? As we saw in the Trayvon Martin case, where a boy was killed for simply walking home, individuals who have done nothing wrong can be seen as imposing reasonable fear in some people. Furthermore, once the individual makes the decision of what is reasonable and acts on it, how do the courts interpret it? In most legal structures, cases that don't have a definite answers are left to precedent. However, in these cases, precedent is so convoluted that there seems to be no actual answer for what is reasonable. This can be seen in not only the Trayvon Martin case, but also the killings of Diego Ortiz, Michael de Jesus, and Hamanta Miles. Are people really standing their ground? The lack of a definition and precedent on what is reasonable has led to many cases where people standing their ground actually have plenty of opportunity to safely leave the situation, and has instead even instigated violent acts, sometimes even on unarmed people. One such case occurred when 21-year-old Byron Thomas shot and killed unarmed 15-year-old Hamanta Miles as he was fleeing from Thomas in a car. Miles and 6 other teens argued with Thomas after trying to buy marijuana from him. As the teens were fleeing after the argument, Thomas fired several shots from a 9mm pistol into their moving van, killing Miles and injuring another teenager. Thomas was not charged due to stand your ground laws. Another case involves 61-year-old Joe Horn shooting and killing Diego Ortiz and Miguel de Jesus. Horn saw Ortiz and Jesus robbing his neighbor's house. He called 911, where he stated he was going to go shoot them. After the dispatcher told him not to, he chose to leave the safety of his house and followed both men to shoot them in the back while they were fleeing. Despite not being in any danger and being told by dispatch not to shoot, Joe Horn was cleared due to stand your ground laws. Yet another example is the murder of Jordan Davis. 49-year-old Michael Dunn asked 17-year-old Jordan Davis and 3 of his friends to turn down their rap music while they were at the gas station. Davis does initially turn down the music, but Dunn escalates the situation by continuing to confront Davis and his friends. During the confrontation, Dunn states that Davis threatened to kill him and was getting out of his vehicle with a weapon. This is when Dunn shoots 17-year-old Davis. Dunn states that he was acting in self-defense, and later during his trial, his attorney attempts to utilize the stand your ground law to prove self-defense. It was later proven that Davis had no weapon, but was still shot and killed by Dunn. There are many cases of this type of situation where innocent people are being murdered, and that murder is attempting to be justified because of the stand your ground law. Defending yourself is one thing, but legalizing taking the law into your own untrained hands is another. If it wasn't for the stand your ground laws allowing incidents like this, Diego Ortiz and Michael de Jesus would still be alive, as Joe Horn cited stand your ground laws while shooting them, and Hamanta Miles and Jordan Davis would have justice. Do stand your ground laws save lives or cause more problems? The deadly disadvantages of stand your ground laws. Stand your ground laws escalate conflict. There is solid evidence that stand your ground laws increase homicide rates and violent crime. We will focus on 3 landmark studies to prove that stand your ground laws do more harm than good. Number 1, a study by Degley in 2022 compared U.S. states with and without stand your ground laws. It concluded the implementation of stand your ground laws resulted in a significant increase in homicides, including homicides by firearms. They found that 248,358 Americans were killed due to stand your ground laws. They also noted that in states where stand your ground laws were enacted, the homicide rate increased by 8% to 11%. Number 2, the American Bar Association completed a 12-month study on the effectiveness of stand your ground laws in 2014. They used a decade's worth of data to look at the impact of the law found from a criminal standpoint. The ABA found that the presence of this doctrine in place of a duty to retreat did not have a deterrent on serious crimes. There were even incidents where law enforcement actions were impeded because of the presence of this legislation. Finally, number 3. The Tampa Bay Times has done a superb job of documenting nearly 200 cases in which defendants asserted stand your ground claims, resulting in dismissals 70% of the time. In nearly a third of the cases, explains the Times, quote, defendants initiated the fight, shot an unarmed person or pursued their victim, and still went free, end quote. Judges appear uncertain about the boundaries of the doctrine, and court outcomes are inconsistent. Defense attorneys now make stand your ground claims in hundreds of cases per year. They have a strong incentive to do so because the burden of proving the defendant did not feel threatened now falls on the prosecution. The presence of stand your ground laws increase violent crimes even when the context does not fit the criteria, or in other words, stand your ground provides legal validation, even if not technically justified, to escalate conflict in the name of self-defense. These studies illustrate how stand your ground laws do not stop violent crime. In fact, they increase it. Stand your ground laws also disproportionately harm racial minorities. As can be seen in the chart depicted, courts disproportionately rule in favor of stand your ground laws in cases where a white person kills a person of color. In a different study published in the American Public Health Association, it was discovered that stand your ground cases that involved racial minority victims ended in conviction less often than those with white victims, regardless of sample size and whether the studies adjusted for other case characteristics. The Rockefeller Institute of Government explains it more simply, stating that homicides in which white shooters kill black victims are deemed justifiable 5 times more frequently than when the situation is reversed. We've already established in our previous arguments that stand your ground laws increase the number of homicides. We cannot enforce a law that not only increases homicides, but also doesn't punish those homicides when they are committed against people of color. What would happen without stand your ground laws? Proponents of stand your ground laws argue that stand your ground laws have crucial benefits, citing the protection of the right to self-defense and deterring violent crime. But we have shown that not only do stand your ground laws escalate conflict, increasing homicides by more than 10%, but it is also important to note that the alternative, maintaining the duty to retreat, is much safer and protects the victim. The alternative to stand your ground laws is the duty to retreat. This refers to the duty of the possible victim to attempt escape before they resort to lethal force. If retreating is not safe or viable, then the victim has legal protection to respond with merited force. In the US, this was common practice until 2005, when many states removed this duty and implemented stand your ground laws. Currently, only 11 states still employ duty to retreat. A noticeable exception to the duty to retreat is the castle doctrine, which states that if the attack occurs in one's residence, they are permitted to use force prior to retreating. The duty to retreat is a viable and more effective alternative to stand your ground laws. One study looking at homicide rates in states that switched from duty to retreat to stand your ground laws found that homicide rates were higher with stand your ground laws. Taken together, the alternative to stand your ground laws protects victims and encourages de-escalation. This means the harms of stand your ground laws are unjustifiable. Stand your ground laws, while intended to empower individuals to defend themselves, ultimately exacerbate violence and perpetuate racial disparities. Instead of deterring crime, these laws often escalate confrontations, turning minor disputes into deadly encounters, where lethal force becomes an option rather than a last resort. Moreover, the unequal application of these laws disproportionately affects marginalized communities, leading to a tragic imbalance in justice. For any more information on this, please see our works cited, as we obtained all of our information used in this presentation from these sources.